Immigration update for July 16th, 2013. Now, I guess to start off, first of all, there is you probably know this, but if you don't, boy, you really do want to know this. There's a brand new I-9 form. Now, just so I don't miss anything on any of this stuff, any employee who is hired after 1986, which is pretty much everybody, anybody hired after 1986 has to have a valid I-9. The key word there is valid I-9. Now, the new I-9 form, and hopefully you went on FON yesterday because we always post the PowerPoints, and they're still on there today, but you can go on FON and download this entire PowerPoint presentation just for kind of research stuff. But there's a link here to the I-9 form. I won't bother doing that right now. But the part that I want to emphasize here that the government has really been banging the drum, there's a new Section 1 of the I-9 form. Okay, so every employee has to fill out an I-9 no later than the date that they're hired. Section 1 must be completed. I'm parsing my words so deliberately here because it's so important. Section 1 of the new I-9, which went into effect May 7th of 2013, so a couple months ago. Section 1 has to be completed correctly and no later than the first day of employment of that particular employee. If it is not filled out, or if it is not filled out completely, or if it is not filled out completely and somehow they can tell that the date on it did not coincide with the date of the initial of the employee's hire, you will be fined severely. The penalties are very nasty. So we don't want that to happen to you, so we want to tell you about that. Now, back on March 8th, the immigration folks, they released this new version, and it was kind of out there, but it really didn't go into effect until May 7th, so they're trying to get some information from the public, as they usually like to do. Now, as far as procedures go, there's a handful of things that you have to do. Some of these are kind of the same as the way you've been probably doing I-9 administration all along, but some of this is a little bit different. So I thought rather than just kind of point out the changes, I would treat this Smartcast as kind of like, well, we'll just tell you everything. We'll tell you how to properly do immigration administration. The first step, or the first procedure in I-9 administration is verification. Verification. Employers perform I-9 verification by requiring all new hires to complete Section 1 of the form and present that documentation, confirming that employee's identity and their authorization to work. This could be with a green card, it could be with an H-1B visa, it could be with their driver's license, official documentation. Number 2 is the employer must then record the documentation in Section 2 of the form. So the stuff that your employee is presenting to you that you are accepting in accordance with the regulations that are authorized documents that say this person can work in the U.S. Then you have to put that documentation in Section 2 of the form. Number 3, the ICE people, Immigration Control Enforcement, under the U.S. Citizen and Immigration Services Agency, have released this new I-9 form, and they've also released a number of things that would be perhaps helpful for you to have on hand. One of them is called the Employee Eligibility and Verification Manual. I don't think it's all that big. I've seen it. I mean, it doesn't look like it's, I didn't count the pages, but it doesn't look like it's that big. But it's a very good thing to have on hand because ICE is particularly nasty. I have, in Wisconsin, for example, where I live, ICE made a swing through an area where I happen to have a vacation home, and they were just ruthless, and it really put a lot of damage in the community. A lot of people lost their jobs. There were a lot of people that were fined. It's pretty bad stuff, and there are a lot of people out there that are unauthorized workers. So ICE is also beefing up their enforcement. So whereas maybe you thought in the past that the chances of me getting an I-9 audit are fairly remote, I probably would have said, yeah, unless you're a medium to large company, because that's where there's a lot of fines. It's not that case anymore. We're talking a lot of small companies. They come knocking on your door, and you've got 30 minutes to produce all of the I-9s, 30 minutes. So this employment eligibility and verification document, good thing to have on hand. Also, the handbook for employers and instructions for completing the Form I-9. That was released on March 8th of 2013. A little story here. We've done a lot of I-9 basically audits, and for some reason we started doing a lot of these in the Chicago area for some of the small cities and villages. And the aldermen, at least in the cities, they'd be called aldermen, were very concerned because somebody scared the death out of them about these I-9s, and with good reason. And so they would have people that, like in the summer, they'd hire somebody to run the rec department. They'd hire people to cut the grass, work in the parks, and you get the idea. And a lot of those people were questionable as to whether or not they were allowed to work legally in the United States. And the aldermen were kind of going, boy, if we're not riding herd on this kind of thing, we could be the ones that will get in trouble. So it became kind of a political issue. So anyway, we did a lot of audits, and what we would find is that it would be rare that we would find an I-9 that was completed properly. That's the same thing as saying that, of course, we would tell them and have them get them up and straight. But the fact that there were so many of them that were incomplete or had little problems, or they'd use the same pen to sign like 50 I-9s, I mean, what are the chances that if you're supposed to have an I-9 filled out on the date that the person hires, that you'd have 50 of them at all different dates when they were hired, and they all use the same pen, tip-off? This is how the game goes, and they're pretty nasty about this stuff. So having the instructions for completing the I-9 is much better than this presentation because it is the real deal. It's not fun to read, but it'll help you out. Now, as far as when this all went into effect, it is in effect. Employers have to use this new form exclusively. So any old ones you got prior to May, or actually prior to March, throw them away. They're no good. Don't fill them out. They're no good. So in essence, you're going to have all your employees fill out a new I-9 form, and it's the one that we're talking about right here. Penalties. The Immigration National Act, the INA, provides for civil and monetary criminal penalties. We don't like to hear that. For record keeping and paperwork violations. So if ICE comes into your door, like I say, you have 30 minutes to produce the I-9s. If you can't do that, or if you're not keeping proper record keeping, well, for every violation, for every employee that they can count up, it'll range, and I'm not exactly sure how they assess the proper amount in the range, but the range is from $110 per occurrence to $1,100 per occurrence. Now, from what I've sort of heard through the grapevine with employers that have been affected by this, is like if they've caught you a couple times, once they get you on the radar screen and they come back, and if you haven't fixed up your situation, then the fines go up, but they will keep fining you. Paperwork violations would be anything that's missing or anything that was not done in accordance with the actual instructions for the I-9. Like that example I gave you where there were 50 people and they were all hired at different times, but they all used the exact same pen. It doesn't make any sense. And ICE would flag that and say, you just signed these things because you knew we were coming in, kind of a thing. Number two, you can be fined, or you can even have a criminal penalty levied against your company for knowingly employing an unauthorized worker. Well, I think we all know that. The penalties range from $375 to $3,200 per occurrence. So for every person that they find, you're going to pay a fine in that range. For the first violation, first time they catch you, $3,200 to $6,500 per occurrence. They catch you a second time. In other words, they didn't like what they saw the first time, and they think, boy, they're not running a tight operation here. I think we're going to score if we come back a second time. And if they come back a second time and they find something that's wrong with those I-9s, $4,300 to $16,000 per occurrence. For the third and for more, that would be actually is how that should actually read. So the money is not small. For a demonstrated pattern of practice of knowingly employing unauthorized workers, that's where the criminal action really kind of comes into play, and then you would be assessed a criminal fee of up to $3,000. And this sounds terrible, my friends, but you would face the possibility of imprisonment of up to 6 months. Now, those are all in the brand new instructions on completing the I-9. I know that sounds kind of harsh, but don't shoot the messenger. Now, there are some anti-discrimination provisions in the INA, that particular law. And the anti-discrimination provisions also limit the type of questions that you and I, because I'm an employer, the kind of things that we can ask of job applicants. Now, for example, these are two questions that you can ask without, and we're getting into the weird zone here because you think that somebody who's an illegal alien, that you wouldn't have to kind of do a little dance around asking them without discriminating against an illegal alien. I don't mean that to sound political, and I hope it didn't come across that way, because I just find this just a little bit strange. But here are two questions that you can legally ask an applicant who comes to work for you. Now, you can ask this of everybody, and you're safe, but it's particularly important that you do not discriminate against somebody who you may think, by the way you look at them, by the way they speak, as to whether or not you have any doubt as to their authorization to work within the United States. So here are the questions. 1, are you legally authorized to work in the United States? Yes or no? That way you put the hook on them. Now, if we find out through either E-Verify or through their I-9 or something else that's been falsified in a document, well, you have done the right thing. And in asking that question and having it documented, that severely or strongly gives you a defense against any one of these immigration agencies, and there's quite a handful of them today. That gives you a defense to say, you know what, we tried in good faith to determine, without discriminating against anybody, whether or not they were legally authorized to work in the United States. The second question, and this is also fair game. These are right out of the instruction manual, by the way. Will you now or in the future require sponsorship for an employment visa status? Now, that one's a little bit more of a tip-off. I was born in the United States, probably like everyone on the call here. I've got my Social Security card. I'm in a little hospital where I was born. I'm a citizen. I mean, that kind of stuff doesn't really even apply to me. But for individuals that you might be skeptical of, again, what you're doing is you're setting yourself up with a defense. You're playing defense on this one here. So if you get audited, you have tried in good faith to do the right things. So ask these two questions, and the second one is the more telling of the two. Will you now or in the future require sponsorship for an employment visa status? Kind of gets to that H-1B visa stuff. The audit process. I said 30 minutes, and I was wrong on that, so please, that was my bad. Actually, it's 3 days. I was thinking of the OSHA material here. I got mixed up there. The Immigration and Control Enforcement Division usually initiates an I-9 administrative inspection process by serving an employer with a notice of inspection, an NOI. Not a good acronym. The NOA compels the production of Forms I-9 within 3 business days. So they send you a little letter, or they knock on your door, or they give you something certified mail, they send you a letter in the mail, whatever it might be. They will notify you. And at that point, you're on notice, and you have to then, because they're going to come a-calling, and you want to have some good coffee on, and you'll have 3 business days from that point to produce all of the I-9s for all of your employees. And all of those I-9s must be the brand new I-9s. Now, things happen in business. We all know that. Sometimes things are kind of hectic. So there is an extension that may be granted at the discretion of the investigating officer. That's why the cup of coffee might help. I'm just kidding. The NOAA will indicate whether ICE requires any supporting documentation, such as a copy of the payroll, a list of current employees, articles of incorporation. That one, I'm not really sure why they need that, but it's in the rules. And business licenses. Now, some businesses don't require a business license. I don't have a business license, but some businesses do. And so there must be some information in there, and I'm not really familiar with that part. But if you're a company that has certain business licenses that you have to post, for construction work or whatever you do, they can rightfully ask to see all of that, and you're going to have to produce all that material. So again, you got the PowerPoint here, and of course the movie will be on FON pretty soon after this particular presentation. But that's the audit process. That's how it works. Now, things that you can do and should do right now. Number one is in-house procedures. I know this is a lot of gobbledygook and a lot of pushing paper around, but these are the rules. This is legal guidance that I have read and clipped and put in here. So this is not my response. So this is from an attorney. Number one, adopt written procedures providing clear guidance to human resource managers. Written procedures, not verbal. Clear guidance, not ambiguous. This is exactly what you will do. The procedures should address who is responsible for conducting the I-9 verification, accountability. Make sure that your in-house procedures have who's accountable for what, and hold them accountable. Number two, continuing on, who is responsible for conducting the actual event of the I-9 verification? Who is that person? What's their name? Put that in the procedure. And who is subject to I-9 verification? That's a person. Put it in the procedures. Accountability on this, so nothing falls through the cracks. All of the things that need to be done, somebody is accountable, and somebody has been trained on these things, and you really are kind of bulletproofing your company against any problems. Also, how the I-9 should be stored and retained, because there is the record-keeping requirement, and how to develop a sound I-9 compliance system that is integrated with the company's overall personnel and hiring policy. Now, that seems to really imply that really whoever handles the HR in your company, that probably is the individual or his or her group where these in-house procedures should be, one, developed, and number two, should be housed, and the people within that group should be the people accountable. That is an important thing you can do right now, and I strongly urge you to do that. Number 2 is appoint an I-9 manager. This is an overseer kind of a thing. It's somebody who has overall responsibility for the list of things that we just got done discussing in the previous slide. Now, probably that's the HR manager, and you're probably the HR manager. So maybe that's you. If that's you, or whoever that person is, the I-9 manager, that person is responsible for, 1, training employees responsible for completing I-9s. Now this would be like, this could be, depending on how centralized or decentralized your HR is, this could be a hiring manager, it could be somebody in HR. I like the HR thing because, number 1, you guys understand this stuff. Number 2, you're centralizing something that's very, very important, and that has a real serious downside in the way of fines if you mess it up. And let's face it, line managers, this is not their bailiwick. So I would recommend, and this is just my personal advice, centralize the I-9 management within the HR unit and train them on how to do it. Number 2, oversee compliance. The I-9 manager oversee the compliance and help ensure that it becomes part of the corporate culture. With assistance of an attorney, if you want to go that route, a little pricey sometimes, employers should conduct periodic reviews of the company's I-9 files to ensure that they're all there, they're all correct, somebody didn't use the exact same pen to sign all that kind of stuff. Regular I-9 audits will enable the company to respond more effectively to a government NOI in a timely manner and demonstrate a good faith attempt to comply with I-9 requirements. Sounds kind of boilerplate with most things that the federal government tells us to do, but you know, it works, and that is what an I-9 manager should be doing. Conduct manager training. Boy, almost every Smartcast that we talk about, we always talk about manager training, partly because everybody's so busy and it never gets done, but number 2, it's so important and it could save you so much money and headaches and trouble if the managers simply were trained on some basic procedures. Here we happen to be talking about I-9, but it could be really almost anything. But let's talk about I-9. Managers that are responsible for hiring, negotiating service contracts, think about that one, should be trained on the I-9 requirements and the procedures, the potential penalties that the company faces if they mess up out of their ignorance for I-9 violations, and behavioral risks like joking about illegal aliens in the workplace. Not a good thing. This falls right into the same category, although it hasn't risen in terms of the regulations. Joking about illegal aliens is a type of discrimination. Technically, it would fall if the person is in fact an illegal alien. That means they're from another country. That technically would fall under Title VII of the Civil Rights Act of 1964. Now, when you get a Title IX violation, the saying that you are innocent until proven guilty in a court of law, that does not apply for Title VII. It's just the opposite. Title VII, you are assumed to be guilty when there is a claim levied against you. You are assumed in any type of Title VII claim. The employer is assumed to be guilty. In other words, you have to prove that you are not guilty. So it's just the opposite. I don't know, maybe some of you knew that. I find out a lot of people don't know that. So train your managers on these I-9s. Give them those instructions. Give them that manual. Sit down, talk about it. Does anybody have any questions on this? That kind of thing. Review contracts with service providers. Contracts that you have with your vendors that help you do your business should contain express provisions making the completion of I-9s for contractor employees, and the contractors are responsible for doing that. You want to make sure that you have language in your agreement that the contractors, they're doing their I-9s, they're making sure that they're hiring people that can legally work in the U.S., and that if they fail to do that, it is their responsibility. So it's kind of a hold harmless provision. Now, there's a typo here in this next sentence here, where the host, it should say host company. Where the host company has sufficient leverage, it may be desirable to include provisions requiring the contractor to indemnify the company for any costs, damages, penalties arising from the contractor's failure to comply with IRCA and other legal requirements like workers' compensation. Now, I realize that what I just read in that little paragraph to you sounds like, holy cow, you mean we got to redo our service contracts and get them to sign these things? Well, the reason that although it's very onerous, the reason you want to do that is because sometimes service providers work so closely with an employer, with, say, your company, that it somehow kind of gets a little bit difficult to really determine if you might be squeaky clean as an employer with your I-9s, but the service provider who's got an employee that's working in your facility or your plant or wherever the work is done, and that person, we find out, happens to be an unauthorized worker, the question becomes up then, well, you, the person I'm talking to on this Smartcast, why didn't you know that? You should have known that. That is the attitude that the government is taking on these new I-9 provisions. So, I know it's a pain, but review your contracts with the providers, and the language that I put in here, put that in there. Consider auditing contractor performance. Okay, so now again we're dealing with their vendors here. Conduct periodic audits of contractor I-9 procedures to ensure that they, the vendor, is complying with the IRCA's requirements, if such audits include reviewing the contractor I-9 forms. However, they may be used to bolster an argument that the company is a co-employer of the contractor, which means there is culpability on both sides. The vendor, they may have the illegal or the unauthorized worker, but this co-employer doctrine means that you, squeaky clean employer, because you're sitting on the Smartcast and you're learning all this stuff, you may have culpability as well, and that equals fines. So again, I realize that I'm asking you to do things that you're going, we don't have anybody to do this kind of stuff. We have no time as it is. But I'm trying to give you prudent advice, kind of just a catch-all. Make sure you're dealing with contractors, vendors that are on the level that you trust. They run a straight-up business. And it's a good thing to talk with your contractors, to talk about these I-9 things. And in the previous slides where we talked about occasionally doing an audit of some of your vendors, particularly if you think that you're suspicious that there might be something strange. This gets very unusual here in terms of the relationship, but it's kind of where the law has placed us. Okay, now there was a ruling at the end of June, at the end of June, the Supreme Court, and they dealt with this with DOMA with regard to same-sex marriage. And it has to be brought up because it's going to apply to a handful of states and, of course, many, many, many companies in those states. Now, each of you know if you're in a state that permits legal same-sex marriage. Where the issue between immigration, DOMA, and the Supreme Court rule, where the nexus kind of comes together, is that the SCOTUS rule means that employers like you in states that recognize same-sex marriages, so if you're in a state that recognizes same-sex marriages, you then must amend your employee benefit plans and your human resource policies. And the HR policies are probably going to be the more devil in the details one. And you have to amend those benefit and HR policies to allow for spousal benefits that now apply to an employee who's married as a same-sex partner. Now, we've had, and some companies have practiced, the doctrine of domestic partners. What this Supreme Court decision means is that in those states that currently, and maybe some will join down the road and pass laws to become states where they recognize a same-sex marriage, if, let's just say that you have a person, excuse me, you have a person who is an American. They're a citizen of the United States. And let's just say that they marry in a same-sex situation a person who is of questionable legal status when it comes to immigration and their right to operate in the United States. Now, we're waiting for further regulations on this at this point, but what we have been able to read and understand, and what just in the knowledge circle that's out there, is that if you have a same-sex marriage state and you have an employee who's fine and dandy as far as an employee and their legal status, if they're married to somebody who is an illegal alien or has some right to stay in the country for a period of time, but they are an unauthorized worker, that person, hear me clear, that person, under the ruling by the Supreme Court and the fact that you, let's just say you're in a state that recognizes same-sex marriage, that married spouse who is an unauthorized worker is now entitled to all the spousal benefits that you may offer, and any kind of spousal benefits and obligations, by the way, that exist in your human resource policies. That's what that means. Now, Wisconsin, again where I live, Wisconsin does not recognize same-sex marriages. So Massachusetts, who I was talking to somebody there earlier this morning, Massachusetts does recognize same-sex marriages. So everything I just told you applies certainly in Massachusetts because they're a state that recognizes same-sex marriage. Let's just say that that same-sex couple were to say, you know what, I'm tired of Massachusetts, I'm taking a job, or one of them is taking a job, or both, they just decided to move to Wisconsin. Now, that same-sex married couple, none of this would be recognized in Wisconsin. So the rights that they have in a state under the Supreme Court ruling that they have the exact same rights as a heterosexual married couple, that would not apply in most states because most states do not have recognized same-sex marriages. So it only really is valid in the state that has, it comes down to, do you live in a state and employ workers in a state that has a same-sex marriage legality on the books, then everything I just done applies. If they don't, then it does not apply. It seems complicated, but it's really that simple. If you are in a state that does not recognize same-sex marriages, the best that these particular two individuals could have would be perhaps, and again this depends on the state too, perhaps a civil union. But a civil union would not rise to the level of the partner in a same-sex marriage, the partner of the employee for your company, having full access. It would be the same thing as if you offered domestic partner benefits. Not quite the same. It's a lesser standard. It's a lesser standard. And so you might have some questions on that, and because it's kind of a big topic. Okay, well, again, I'm sorry for that little telephone blip where I got dropped off, but I'll take any questions that you have. Just go ahead and write them down or raise your hand. Oh, we've got a lot of written ones here. Okay, do we have existing employees fill out new I-9s? Yes, you do. Yes, you do, because the current one is no longer valid. If we go back now retroactively and have our current employees do a new I-9, is it okay to do those en masse and in the same ink? Yes, it is. Yes, it is. It may flag from somebody from ICE, but as long as you explain what you just got done asking me here, I mean, that was simply a matter of efficiency. That's why you did that. So that'd be fine. I can't hear anything now. I'm sorry. I do understand that. Lost audio. Lost audio. I have no audio. Yeah, I'm sorry. Sorry, folks. I really had nothing to do with that. Everybody lost the sound. Okay. Okay, here's an I-9. If an I-9 has been performed and problems have been found, what are the procedures to correct the errors? Well, the procedures to what I would do, I would simply have the employee call the employee in, depending on what the nature of the actual error is, and have them correct the error and then initial it, and then have you initial it, because that shows that you are on top of these things here, and you are showing a good faith effort to make sure that they're done properly. That's how I would handle that. You could have them fill out another I-9. Now, well, I guess that brings up a secondary issue. If they filled out the current I-9 and there's some errors on that, then I would just have them correct the errors and initial it. If it's an old I-9, I would just have them fill out a brand new I-9. I'm back on. Good, thank you. I'm back on too. Does the new form need to be completed on all employees currently employed? If so, what date should be used, and is it a recertification or a new form? It's just a brand new form. It's not a recertification. You're not recertifying anybody. You're simply they've introduced a new form, and you are now compliant only if you're using the new form. I have been using the new form since May 7th. Good. On all new hires, but did not go back to existing employees and complete the new form, but utilize the form completely at the time of their employment. Okay? All right, well, my understanding is that that form is now obsolete, so you should have everybody. Now, you don't have to do this, like, you could do it en masse, but you could also do it, on a more gradual basis, because the thing is you still have an old I-9 that has been verified. It's just that old I-9 is no longer valid. Now, I mean, if ICE comes in today and says, okay, let me see all your I-9s, and you got a lot of employees, and some of them have filled out the new I-9, some of them you still have the old I-9, and you explain to them, look, I'm making a good faith effort to try and get everybody to fill out the new I-9. I just can't imagine where that would be a penalty for you. That seems like a very logical and methodical way of actually complying with the law. Okay, did you say that if a same-sex or opposite-sex couple has an illegal partner, we still have to cover the partner with benefits? Yes, I did. Yes, I did. Provided that you're in a state that recognizes same-sex marriage and these two people are married. They're same-sex married people. because that person then is a spouse and entitled to whatever spousal benefits your benefit plan and your HR policies, wherever they may address spousal benefits. How do I download the PowerPoint presentation? It's very simple. Just log on to FON, Future Office Network, and you will see you can go under Smartcast, which is right on the first page there. You'll see that. You can click on there. You can click on the PowerPoint presentation, or even right now on the very right-hand side, it'll say like latest documents, and you'll see the actual PowerPoint presentation right there as well. So that one's pretty easy to do. With employees operating in multiple states, would they need to amend benefit documents and policies to reflect SCOTUS? Yes. Yes. The High Court is the law of the land. What date do you use on existing employees with hire dates prior to May 7th? Okay, let me think about this. What date do you use on existing employees with hire dates prior to May 7th? Well, first of all, you'd use the date that they were hired using the old I-9 form since 1986. So, I mean, we're way years down the road on that. But what we talked about in this presentation is that you should bring all of your employees onto the new I-9 form, Can I just make an addendum form for our contractors stating that they attest that all of their staff members are in compliance with current I-9 rules? We don't have contracts with our vendors, with all of our vendors. You know, that one might be a legal question, and I'm not an attorney. And so it comes down to a legal opinion as to whether or not that would pass muster. So I'm gonna give you my standard disclaimer here. I'm not an attorney. I'm not an accountant. I'm a consultant. As a consultant familiar with these matters, I would think that would suffice. But I would make sure that the addendum is worded really, really technically. No like little loopholes where they can sneak out or any kind of thing like that. Make sure that it's very, very correct. That actually seems to make a lot of sense to me. But if you don't want to take my advice for that, well, then I would contact your attorney on that particular piece. If all current employees are filling out a new form, doesn't that violate the rule that the form must be filled out at the time of hire? No, it doesn't, because probably, hopefully, that you, under the old I-9, when those employees were hired, you had them fill out an I-9 at that point in time. And so you still have that I-9. I wouldn't throw it away. I would, stack them and put them in some old warehouse or somewhere, because you may need to prove that. But where it's important that on a going forward basis is that Section 1 of the new I-9 has to be completed no later than the first day of employment. That's what the rules say. Now, to me, it's not that big of a form. I mean, it takes about 5 minutes to fill it out. Why the feds decided to pick on Section 1, I don't understand that, but that's what the rules say. You will be fined if they don't. Now, I think the prudent response is to have a new employee, before they start their first day of hire, complete the entire I-9. I mean, why have them look at a simple little document twice? Doesn't make any sense to me. So I would just have them fill out an I-9, which is probably how all of you have been doing this all along anyway. What is the deadline for having new I-9 forms for all employees? They really haven't given us a deadline. They just simply said that, what did I say, it was May 13th of this year that the new form became effective. As far as the deadline for having all of your employees that have been with you for some time prior to the new form, getting them on the new I-9, there is no guidance that I've seen on that. I cannot answer that question because I've not seen any rule on that. What date do you use on the new I-9 for existing employees, the current date or the original hire date? What you do is you'd use the original hire date. The original hire date, because that's really what they're trying to get at. Are we required to do any further citizen checks besides just having them fill out the I-9 form? You can, no, the answer is no. You can, the I-9, if it's filled out properly and if you follow the directions, that suffices as your due diligence in seeking to hire an authorized person to work in the United States for your company. Now, another way you can do this, you can use the E-Verify system, which is an online electronic system that will tell you whether or not this person is listed in the government databases as a person who is authorized through some documents that they have completed somewhere at some time, whether or not they're authorized to work in the United States, and of course that would mean for you too. But no, if they fill out the I-9, that's enough. If we are completing new forms for old employees, we are using the current date or the signed date. I think we already answered that question. You use the original date. Can an employer make employment contingent upon completion of a Form I-9? Yes, you can. I mean, if they can't complete an I-9, then you have no way of knowing, according to the rules of the Immigration and Naturalization Service, you have no way of knowing if that person is even authorized to work for you or anybody else in the United States. And if they are, in fact, an unauthorized employee that you're employing, well, we went through the penalties on that. Those ones were really stiff. Okay, that's the end of those questions. Let me just go and see if anybody raised a hand here and if there's any ones there. Okay, Linda, how you doing? I see you raised your hand. Do you have a question or a comment? Linda Koch?
Hi, I'm sorry. It's more of a clarification on a question.
Okay.
If we're filling out new forms for existing employees that have been here for years, I mean, obviously for their hire date, we're going to use their original hire date, but where they sign the form and then put the date that they signed it and we sign it and put the date that we signed it,
right.
You're saying we should use their original hire date for that as well?
No, I'm sorry. Thank you for bringing up that point. You put down the date when they were originally hired because that's accurate. That's true. I mean, if you put down like today's date, that would not be true because they've been with you for a month, 5 years, 10 years, whatever. So you put down the date of hire, but the date that you filled out this form and you date it and sign it, you put the date that you actually signed it. So if you did that today for 1 or 2 employees or whatever, and Linda would sign it, she would date it, and Joe Smith, whoever the employee is, would sign it and date it for today's date. That would make it complete.
Okay, that clears it up. Thank you.
Good. Thank you. That's a great question. Thank you for bringing it up. Okay, any other hands up here? I don't see any here. So, well, folks, thank you very much. Please fill out those evaluations, and we look forward to hosting you on a Smartcast. This one has been recorded and will be available on FON as a movie podcast, so you'll be able to listen to it and go over it again. You'll have this big gap of dead air where I passed out, but I'm just kidding. Apologize for that dead air. Thank you, and have yourselves a really good day.